And joining us now in the studio, our good friend, the director of the Mississippi Justice Institute, Aaron Rice. Good afternoon there, Aaron. Thanks for coming in.
Good afternoon, Gerard. Thanks for having me.
You bet. So what is new in your world? I know one thing in particular that we wanted to discuss today, and we can just go ahead and launch right into that, something that I have, been somewhat outspoken about, and I know you have, and many others in the state, and that's the Certificate of Need laws, a.k.a. CON laws.
CON,
all caps, by the way.
Which is a good name for it.
So it just doesn't seem like we're able to get any traction here in a conservative state where we've got these really onerous regulations, if you will, that prevent the free market from finding its level of stability and just normalcy in healthcare.
Yeah, you're exactly right. I mean, I think a lot of Mississippians would be surprised to hear that we have, Soviet-style central planning in our economy here in Mississippi in 2021.
Yep.
But the fact of the matter is we do. We absolutely do in our healthcare sector. And you're right that it is kind of an intractable problem. I mean, the honest truth of it is that there's a lot of lobbying that's done to keep it in place by people who benefit from it. And, the honest truth, too, is that's one of the reasons that we're taking this to the courts is because it is such a problem that just can't be dealt with politically, it feels like. And so it is difficult to take a challenge like this to court, but that's why we're willing to do it is because something's got to be done here. I mean, it's so absurd, and there's lots to talk about on that, but it's such an absurd situation, and it's existed for so long, and it seems nobody's willing to deal with it.
Yeah. As I recall doing some research on this, I've done a couple of panel discussions just as an advocate for eliminating these laws, these ridiculous regulations that prevent the free market from finding, again, its kind of degree of just normal that the market would dictate. This goes back to like the 60s, I think, in New York, as I recall, was where it was for. And it was all about not having too much health care, which is crazy.
Crazy, yeah.
You guys don't know what you're doing. You may build too much or have too many health care resources and just go out of business, and then we wouldn't have any health care.
Yeah, you're exactly right. It started originally in the 1960s. The federal government used it as kind of a way to allocate federal funds that were going to be used to build taxpayer-paid-for hospitals. But then, just like you're saying, hospitals quickly caught on that this could really benefit their bottom line by using these CON programs. And so they started lobbying for them in states around the country. And Congress took notice of it in the 70s and said, hey, we're paying a lot of money for Medicare. And at the time, they were paying on a cost basis. So they were paying, for the cost of the services. And they thought, we need a way to keep the cost down.
Yeah.
And they were kind of convinced that this would be a way to do that. And we've been talking about CONs for a while here and haven't really told the listeners what they are. But this is a system in which if you want to open most type of healthcare facilities, you have to ask the government for permission, show them that there's a need for your service, and your competitors get to basically litigate against you and say, no, there's not enough need, we've got it covered, they shouldn't be allowed in. I mean, if you can imagine any other area of the economy where this would happen. I mean, say you wanted to open a Domino's pizza and you had to go get Pizza Hut to kind of agree with you that, the town really needs another pizza chain. I mean, that's basically what's going on. And so it's really been commandeered, not even as misguided as that central planning kind of thought was, it's really not even that anymore. It's been commandeered by private interests who turn it into a competitor's veto. And so the interesting thing about that is Congress tried this, in the 70s after it got started in the 60s.
Yep.
They mandated that all the states implement this if they wanted to keep their health care subsidies. So every state except Louisiana did. Of course, Louisiana likes to kick the system a lot of times.
Yeah.
And then Congress realized really quickly that it had the opposite of the desired intent. It was driving prices up and quality down.
Correct.
So they repealed it.
And access.
And so they repealed it. But then, once you give people this shield from competition, it's really hard to take it away. And that's what we're seeing now. And so even though the federal government doesn't require it anymore, 49 states had implemented it. And now today it's still 35 that have it. Mississippi is one of those 35.
Right.
Now, in the case we're litigating, and we can talk about that later too, but we're litigating one where even if you accepted all the absurd arguments in favor of cons, it really doesn't make sense here because we're talking about home health care. And so a lot of the rationales are about, if somebody's going to go build this multi-million-dollar hospital, we kind of need to give them a monopoly to incentivize them to do that. You're talking about home health care. I'm going into your home. I'm not building a multi-million-dollar facility. And so when you talk about that, there's only 14 states in the country that do cons for that, and we're one of them. And then to make it worse, we're the only state in the nation that has put a total ban on providing cons, giving cons to new home health agencies for 40 years. And so we're the worst of the worst when it comes to home health care. And that's where we filed our case in, is for our client is a guy named Butch Slaughter. He's a physical therapist. He started his physical therapy clinic back in the 80s in South Jackson. He does a great job. Everybody, you talk to that's a patient of his will tell you what a miracle worker he is. And he saw this problem firsthand with home health care, that it was such a monopoly bureaucratic system that it wasn't providing good care. And so he thought over the course of his career that I could do a better job of that, and maybe I should. And then really COVID kind of showed the need for that even more, because a lot of home health care services, what they do is they really try to keep patients out of the nursing home, delay that or prevent the need for that. And so, of course, during COVID, people are really trying to avoid nursing homes that have been prone to all these outbreaks of COVID. So the need for this skyrocketed, and our client wanted to provide this service and ran headlong into a Mississippi law that says you can't do that. And it's illegal to start a home. Like, you're trying to fix a problem in your community, and we will criminalize that. It's just crazy.
So the way it works, just for the benefit of our audience, and I want to say, you often think about protectionism and protectionist policies emanating from the federal government and sort of protecting, I guess, the interest of industries and within our borders, which too needs to be questioned. But this is protectionism within the state's borders. It's the ultimate cronied up protectionism.
It very is. And that's essentially what we are trying to prove in this case, because as you know, I alluded to this, I mean, it is difficult to take on a case like this because a court is not in the business of deciding whether a policy is a good policy or not. That's not its job. It's to decide whether it's constitutional. And so in this setting, I mean, to show that it's unconstitutional, you really have to show that well, let me back up and say what you just said. Protectionism is not a valid reason for the government to regulate. That's the law.
Sure.
You can't, take away my right to start a healthcare business just to protect somebody else from competition. That's the law. And so in order to get a judge to do this, we really have to show him that is all this con program and moratorium is accomplishing. It's not increasing access. It's not decreasing cost. It's not increasing quality. It's only serving to protect established incumbent businesses. And so, of course, that's a difficult thing to prove. I mean, we have to go out and disprove everything the government says here. Now, I'll tell you, I mean, we've been briefing that, and you may have seen some of that. And it is interesting because you've got 40 years of research that basically every neutral party that looks at this says this doesn't work. The federal government said it didn't work. The FTC has been saying for years that this doesn't work. The Department of Justice has been saying this doesn't work. I mean, it's a very one-sided issue. Everybody who's not vested in it says this doesn't work, and that's one of the reasons that we're willing to take this to a court and say, look, the evidence is overwhelming here that this is not accomplishing what the government says it's accomplishing, and all it's really doing is protectionism, and that's unconstitutional.
I mean, just at a minimum, you're suppressing a person's right to operate a business.
Exactly, and that's why it would be unconstitutional if you don't have a valid government reason to do it, is because our Constitution does protect. I mean, it's due process, it's equal protection, it's all those things that we're familiar with. I have a right to earn a living, and I have a right to start a business in America. I mean, that's the American dream. And so if you, the government, are going to take that away from me, you have to have a valid reason to do that. And here, that's what we're trying to show, is that the government doesn't have a valid reason to do that.
And typically, from a legal perspective, that would mean that it would be in the best interest of society. Overall, right?
Exactly. And so that's what the government will need to kind of show here. Now, I'll admit to you that it's a lot easier for them. I mean, the way the court looks at this, I mean, if they can, they don't really have we have a high burden to show that it doesn't do all of that. They've got a very low burden to just say, there's some reason here to think it might.
You're getting attention.
Yeah, and look, and we would love to accomplish this and get it struck down in court. I mean, we think we have a chance of doing that, and that's why we're bringing the case. And just like you said, though, the legislature needs to be looking at this too. I mean, it's every branch of government should be looking at this.
Can you hang around, talk some more?
Yeah, for sure.
We got Aaron Rice, director of the Mississippi Justice Institute, here on the JT Show, and also when we come back, we got a giveaway right now. We'll get to that after the break. Stay with us. The JT Show will continue. We got Aaron Rice in the studio today. We're talking about the Certificate of Need laws. Of course, Aaron is the director of the Mississippi Justice Institute. So Aaron, you're representing a client who is, I guess, filing a suit. You're filing a suit on his behalf. He is a plaintiff.
Yep.
And you're telling me that there's a moratorium that essentially prevents him from expanding his business, period.
Yes,
right?
yes. And it has been that way for 40 years. I mean, it's a crazy backstory, too, on this moratorium. So we've been talking about the Certificate of Need process and how onerous it is. And just so people understand, you have to spend thousands of dollars on this application. You usually hire attorneys, consultants. Your application is thousands of pages long. Then you get into litigation with your future competitors about it. So that's a very onerous process to begin with. But in our client's case, he can't even engage in that process because there's been a moratorium for 40 years that says the Department of Health cannot issue certificates of need to any new home health agencies. And the backstory, like I said there, is crazy. So what happened is that Medicare back in the 80s moved hospitals onto a flat fee reimbursement system. And so that kind of incentivized them to start discharging patients earlier. I mean, if you're on a flat fee, you want to do the job as quick as you can. And so they did that. But the Medicare did not move home health agencies onto a flat fee at the time. They were still reimbursing them on a cost basis. So it was a lot more lucrative, basically, to do home health than to do hospital care. And so that incentivized hospitals to flood the home health market. They said, look, we can discharge our patients earlier, but when we do, they're still going to need home health care. So we can kind of treat them a second time, treat our own patients a second time as a home health agency at a more lucrative rate from Medicare. And so they started flooding into the market. And existing home health agencies did not like that. They went to the Department of Health and started complaining and lobbying and saying, you got to stop hospitals from getting into the home health business. They went to the legislature and did the same thing. There was this big dogfight, basically, between home health agencies and hospitals about who was going to be able to provide home health care. And so that all resulted in, I guess you could say, the home health agencies kind of prevailed, but it was just a stalemate where the Department of Health and then later the legislature said, look, we're capping it. Nobody else can get into the home health market, okay? If you already had a certificate of need, you can use it. You can keep providing home health, but nobody else can. And here's the crazy thing about that. First of all, that wasn't a constitutional reason to do that to begin with. I mean, to protect home health agencies from competition with hospitals, that was unconstitutional to begin with. But that unconstitutional reason doesn't even exist anymore because later Medicare moved home health agencies onto their own flat fee system too. And so the whole thing that was causing hospitals to try to get into the market doesn't even exist anymore. But this kind of vestige of that old system still is in place. 40 years later, it's still illegal for our client, Butch Slaughter, to start a home health agency.
Unbelievable.
It's crazy.
So, I start thinking about, well, what's keeping the legislature from using that as a precedent just to go issue those same sort of moratoriums on any other industry?
I know. It's crazy. I mean, to think the level of control that's exerted here and kind of the arrogance, really, that's shown here is baffling. And you're exactly right. I mean, it's hard for us to imagine any other area of our economy where the government would just have blanket moratoriums that lasted for decades and say nobody can get into this business. And it's interesting because the government argues in our case that, well, healthcare really isn't a free market. And, demand drives supply instead of the other way around. Or, I'm sorry, supply drives demand instead of the other way around. And you look at it, and it really is just a lot of gobbledygook. I mean, it's like everything that they say, for the most part, they don't really explain it. And it's all just, again, 40 years of studies show that's not right. Yeah. It's not doing what you're saying it's doing.
And for the benefit of our audience, the process, I kind of shift gears a little bit, the process by which, maybe first, what all is covered by Certificate of Need laws? It's not just building new hospitals and new medical clinics. Yeah. It's equipment and hiring staff. Talk about that.
Yes. Well, it can get down into the weeds on things like if you want to buy an MRI machine or a CT scanner, you've got to get an MRI for that. So even if you're an existing healthcare facility and you just want to go buy a new MRI machine, you have to apply for that. And your competitors can come in and say, no, we've got enough MRI machines in this area. We don't need another.
Yeah, let's be clear. You got to ask the government.
Yes.
May I go buy this MRI machine?
Mother, may I please go buy this MRI machine? It's insane. And so, but in terms of just kind of facilities in general, it's defined very broadly, so most healthcare facilities are subject to this. Although, so private practice physicians, clinics, like your family doctor is not covered by this.
Okay.
And then a few others, so like abortion clinics are not covered, veterans homes are not covered, health agencies that are run by the government are not covered, and then some kind of long-term care facilities for seniors are not covered. Basically, everything else is. And so most of the the specialty care you get, the hospital care you get, the home health care you get, anything like that is subject to this. And I think that people have a hard time because they don't necessarily even understand that this is having an impact on them. But I guarantee you it is. I mean, if you talk to anybody, you'll hear stories of people traveling to other states to get health care or traveling within the state to get health care. And I mean, there are people who would provide that care to you if they were allowed to do it. And our government kind of just bafflingly thinks that restricting the supply of healthcare is somehow going to increase access to it, provide more of it, drive the cost down. And experience has shown, and again, virtually every neutral party that looks at this will tell you this, that it has, and honestly, basic economics will tell you this.
Basic economics.
It's basic economics that it's not going to do that. It's going to do the opposite of that.
Well, and I mean, the idea, I don't think most people understand this idea that you got to get permission just to buy a piece of equipment.
Yes.
Certain pieces of equipment. And then, of course, construction of a new hospital.
Yes.
And then there's, I know there's some limitations that are instituted as well with respect to, well, if you want a new hospital, you've got to have an ER. So you couldn't have like a specialty hospital.
You can't have a standalone ER, which
okay.
I mean, and well, you're exactly right. I mean, a hospital has to have it, but think about in our rural areas in Mississippi how great it might be to start a standalone ER because they may not have access to emergency services there. And if you make it that much more difficult to say, well, we'd like to start an ER here, but we're going to have to start an entire hospital if we do that. So, you get into all these unintended consequences, basically. And, but if you zoom out, again, what we were talking about earlier, all of these laws are taking away people's rights that are just as American as apple pie, to say, I have a right to earn a living in America, and I have a right to go out and employ other people or to work for who I want to work for. And all of this kind of just flies in the face of that and says, we're going to take those rights away, and you don't even have a valid reason to do it to begin with, which is just, it's so un-American. That's why I said at the top of this interview, it's a very Soviet-style central planning system. And I really do think most Mississippians would be shocked to hear that we have that in Mississippi, but we do.
I totally agree, and it just keeps moving forward with legs, and we just don't seem to be able to cut the legs out from under it. Every year I talk about it. I talk to my friends in the legislature. I have been an outspoken advocate for repealing these laws, these certificate of need laws. And we just don't seem to be able to get any traction on it.
Yeah. And I think that's what people have to realize, and our lawmakers need to realize, and other people need to realize is, again, when you hand basically a complete shield from competition to an entire industry, I mean, they are going to want to hold on to that, and they're going to spend a lot of money lobbying for it, and they're going to come up with all of, again, I said it earlier, this kind of gobbledygook to justify it. And I think I could see some lawmakers maybe having those conversations and being a little unsure and kind of deferring to, well, it sounds like, you guys have a reason that you think this needs to exist. But I think that there needs to be a little more skepticism involved on the part of our government to say, you have a very deeply vested interest in keeping this, and we need to have a little more skepticism about what you have to say about it. And we need to look at, again, I keep referencing it, the 40 years worth of research on this, what the Federal Trade Commission has to say on this, what the Department of Justice has to say on this. I mean, it's pretty universal out there that everybody else will tell you that this is having the opposite of the desired effect. And so, and the government will sometimes say, or these industries will sometimes say, well, look, our healthcare isn't terrible in Mississippi, so it must be because we have these con programs. And it's like, God, like, how much better could our healthcare system be? I mean, it's such a lack of an imagination. I mean, how much better could our healthcare system in Mississippi be if we didn't have these artificial restrictions in place?
Well, in every report I see, we're ranked last.
I know.
In every healthcare category.
I totally agree with that too. And it is funny because they'll point to some vague statistics to say we're really not doing that bad, and it's like, number one, we are doing that bad, and number two, any quality or any good signs that we have would be a lot better if we didn't have this in place.
No question.
Yep.
We just need to get out of the way.
Yeah,
the market will achieve equilibrium naturally.
Yeah.
That's the way it's supposed to work. Aaron, thanks so much for coming in. Appreciate it, man.
Yeah, good talking to you, Gerard. Thanks for having me.
You got it. The